Bismillahirrahmanirrahim. Assalamu alaikum. Today we are here with another lecture of public international law. So today we will move towards the next about the public international law. So an interesting definition of international law was basically formulated in 1970 by a Russian international lawyer, that was J.I. Duncan. That contemporary international law is the aggregate of norms which are created by the agreement between states of different social systems. So, international law or contemporary international law, like the current international law, is basically a law which is a combination of the norms or the values or the laws which are basically created, जो कि इस सूरत में बन जाते हैं जब कोई भी दो स्टेट्स, कोई भी दो डिफरेंट सोशल सिस्टम्स अल्टीमेटली एक दूसरे के साथ कुछ एग्रीमेंट करते हैं. So basically it reflects the concordant wills of the states and have a generally democratic character. That ultimately that statement basically depict the democratic character of that particular state and regulate the relations between them in the process of struggle and cooperation. And ultimately these laws support both of the states during their time of struggle. Like if one of the state is struggling, ultimately the next state will cooperate them, and if another state is struggling, then the next state will cooperate the state. So basically the two states cooperate each other in the time of their struggles, or even in the time of their development. The cooperation in the direction of ensuring peace and peaceful coexistence and freedom and independence of people, and are secured when necessary by coercion effectuated by a state individually. So basically, simply, international law is basically a law which is generated when the two states done an agreement, when the two social system done an agreement, who are basically democratic characters most of the times, and ultimately they work to basically cooperate with each other during the time of struggle. They basically work with each other to ensure peace, to basically ensure the peaceful coexistence of both the states, to provide freedom to each of the states, to basically provide dependence to their people, and ultimately it basically the basic goal is to achieve a position for each of the state individually in the world, and basically a very strong situation position in the world. So the nature of international law, the nature international law refers to the rules and norms which regulate the conduct of the state and other entities which at any times are recognized as being endowed with international personality. For example, international organizations and individuals in their relation with each other. So the nature of international law basically refers to ultimately, these are basically the rules and regulations which are conducted between two different states, and ultimately these laws basically help to develop the relations or between two states or in organizations or between the individuals of two different states. The nature of international law, the overwhelming majority of the international law, um, international legal rules are basically consistently obeyed. It is probably the case that almost all the nations observes almost all the principles of international law and almost all of their obligations almost all of the time. Like simply, international law is basically followed by all the nations, and principles are followed by all the nations, and to oblige that law and to follow that law is basically an obligation for all the nation for all the time. Like ultimately whenever we go aside from the international law, or we just don't follow the international law, it means the rule or the system is disturbed simply. Then the nature of international law, the basic characteristics of international law are: international law has only a limited number of developed legal institutions. So basically there are very limited institutions which basically work for the promotion of international law in the world. Not every other institutions is liable or has the authority or the responsibility to maintain international law, but instead there are very limited institutions in the world which basically develop the international law. In comparison with international law is decentralized. In comparison of national law, international law is decentralized. So national law is basically centralized. A national law is maintained by a particular nationality or by a particular state, and this law is basically for that particular state. But if in case of international law, it is decentralized. Ultimately different states maintain that international law, and ultimately that international law is not followed by a one country, but ultimately it is followed and practiced by different states. A basic characteristics of decentralized international lawmaking, and ultimately we can see that even the lawmaking process, international lawmaking process, is decentralized international law enforcement. Ultimately the enforcement is decentralized. Like not only one single state can enforce that law, but there we need many of the states to enforce the law. Then decentralized voluntary international law adjudication. So ultimately there are different states which are voluntarily there to implement that law, and not like the whole process is decentralized ultimately. uh, Only one state can formulate international law, neither that can implement international law, neither they can only follow that international law. But we need different states, we need more states to basically formulate that law, to enforce that law, and ultimately to follow that law, or to implement that law. Why is international law binding on states and other actors? So, like there is a command theory, there is a consensual theory or consensus theory, and there is a natural law. We will study them in detail later. So the functions of international law are following: to arrange for the cooperation most actors wish to have most of the time. Like ultimately most of the times there are different actors who wish to basically cooperate with any other state, but they don't know that on what grounds they should cooperate with that other state, or they should maintain relations with that other state. So this is basically international law, which basically define the rules, regulations, and the basis on which an international law must be and an international law is basically formulated or ultimately executed to identify the membership for international society of a sovereign state. So we can say that ultimately international law is formulated by the sovereign state. What are the sovereign states? The states which are independent about their rules and regulations and about their external and internal factors. तो कुछ सॉवरेन स्टेट्स होती हैं जो मिलके इंटरनेशनल लॉ बनाती हैं, और थ्रू इंटरनेशनल लॉ हम इस चीज़ को आइडेंटिफाई कर सकते हैं कि कौन कौन सी स्टेट्स जो हैं वो सॉवरेन स्टेट्स हैं. To regulate the competing interest of the various actors and to carry their agreements into the future. So इंटरनेशनल लॉ जो है वो आपको बिल्कुल हेल्प करता है डिफरेंट एक्टर्स को अपने इंटरेस्ट को compete करने के लिए, और अपने उन इंटरेस्ट को फ्यूचर में जो है वो इम्प्लीमेंट करने के लिए. लाइक इंटरनेशनल लॉ बेसिकली आपको आपके इंटरेस्ट को डिफाइन करता है. डिफरेंट एक्टर्स उन इंटरेस्ट को फर्दर जो है वो कैरी आउट करते हैं, और उन पर इंटरेस्ट के थ्रू वो फ्यूचर में बहुत से बेनिफिट्स जो है वो उनको अटेन कर सकते हैं. to empower weaker state as they press for the change against the will of the powerful. इंटरनेशनल लॉ जो है वो बेसिकली वीकर स्टेट्स को भी बहुत हेल्प करता है कि अगर कोई भी वीकर स्टेट, कोई भी ऐसी स्टेट जो कि सॉवरन स्टेट ना हो, जो कि डिपेंडेंट स्टेट हो, जो कि अंडर डेवलप्ड स्टेट हो, अगर वो किसी पावरफुल स्टेट के खिलाफ खड़ी होना चाहती है तो इंटरनेशनल लॉ बेसिकली उसको सपोर्ट करता है और उसको एक पावरफुल हैंड प्रोवाइड करता है to basically go against that particular state, to promote justice internationally. Basically इंटरनेशनल लॉ इंटरनेशनल जस्टिस को प्रमोट के लिए काम आता है. लाइक अगर कोई भी एक्ट, कोई भी लॉ जो है वो बिटवीन टू स्टेट्स है एंड अल्टीमेटली the states need to resolve that particular issue, so that issue will be resolved, will be on the basis of the international law. Then to outlaw the war, इंटरनेशनल लॉ बेसिकली वॉर के टाइम में बहुत ज़्यादा हेल्प आउट करता है. इट बेसिकली आइडेंटिफाई कि हमें वॉर प्रोसेस से कैसे निकलना है और किस तरह से हमने वॉर को जो है वो लॉस से आउट करना है और किस तरह से हमने बताना है कि व्हाट आर द ग्राउंड्स ऑन द बेसिस ऑफ विच अ वॉर कैन बी इनिशिएटेड, and ultimately if these grounds are not existed, then we can't simply start a war. To empower weaker state as they press for change against the will of the power, to promote justice and to outlaw the war. Sorry, these slides are repeated again, so we have already discussed it, so we won't discuss it again. Then weakness of international law. So how international law is basically weak. Lack of institutions. There are different institutions ultimately to implement the law, but most of the times these institutions are in some specific states. जैसे कि हम देख सकते हैं कि यूनाइटेड नेशंस और यूनाइटेड नेशंस के तमाम ऑफिसेस they basically exist in America. Like ultimately if one state wanted to seek the justice, the institutions is not available in their own state, but ultimately they have to go in a different state to seek the justice. As it is in the institution to promote international law, the institution must exist in every other sovereign state, we can say, or every other developed state. So people should have an easy access to that particular institution to promote justice and law. Lack of certainty. Most of the times the laws, international laws, are not certain because most of the times the sovereign state, if one sovereign state accept that law, the other sovereign state totally denied that law, and because of that particular reason, most of the times laws are not certain because one state doesn't want to accept that law. Then vital interest. uh, that, of course it is an international law and the interest is vital. Like if it is broader, it is big, and ultimately when the interest is broader, we need the consensus. Like most of the times we don't get the consensus of on most of the laws, and ultimately because of the vital interest, because of the non-consensus, मोस्ट ऑफ द टाइम्स क्या होता है कि इंटरनेशनली बहुत सारी स्टेट्स किसी एक लॉ पे जो है वो कंसेंसस नहीं कर रहे होते, और क्योंकि कंसेंसस नहीं हो रहा था अल्टीमेटली एक बेहतर लॉ जो है वो भी इम्प्लीमेंट नहीं हो सकता. सेम इज विद द रूल्स, कि इसी तरह से जब रूल्स बनाए जा रहे होते हैं कि किस तरह से आपने किसी स्टेट के साथ रिलेशनशिप मेंटेन करना है, कब आप किसी स्टेट के साथ वॉर जो है वो इनिशिएट कर सकते हैं, कब जो है वो पीस हो सकती है, ये तमाम के तमाम बेसिकली इंटरनेशनल रूल्स हैं. किस तरह से आप ट्रेड को प्रमोट कर सकते हैं, इकोनॉमी को प्रमोट कर सकते हैं, दीज आर द रूल्स. और मोस्ट ऑफ द टाइम्स क्या होता है कि दो डिफरेंट स्टेट्स आपस में किसी एक पर्टिकुलर रूल पे कंसेंसस ही नहीं कर रही होती, उस पर एग्री ही नहीं कर रही होती, एंड दैट इज़ द वीकनेस ऑफ इंटरनेशनल लॉ, दैट अल्टीमेटली लॉ इनिशिएट होने से पहले ही उसमें काफ़ी ज़्यादा इश्यूज क्रिएट हो जाते हैं. Okay, Ji, thank you so much. That is it for today. Hope to see you in the next lecture, inshallah.